Good morning, folks.
Not true, not true.
We have a special treat this morning. It's a threefold treat. One is that Fred Braid is our moderator of the Holland and Knight firm. Mark Brossman, my current and former boss. I have lots of former bosses, by the way. My current and former boss is going to introduce John Ring, who is, I think, also a colleague of mine from my very few years at Morgan Lewis. John is a very, very able, distinguished labor lawyer who is now chair of the NLRB. And so I'm going to turn it over to Mark, right?
Right. I'm going to go up here. Sam told me to go where I'm comfortable. So I figured standing up is appropriate. I'm honored to be here today. First, I want to acknowledge Sam, actually. Sam this is the 72nd annual Conference on Labor. Sam is.
When I was 2 years old.
You're right. Sam has been running this with his able team for many, many years, but it really is sort of an amazing conference because he brings together practitioners, academics, and government officials, finds really interesting topics that are on the cutting edge, and puts together a conference year after year, which is really as the highest quality possible. So, kudos to Sam and this program. So it's my honor to introduce John Ring. I just met John for the first time, who's now chair of the National Labor Relations Board. He was confirmed by the Senate on April 11th by a vote of 50 to 48. Nobody's surprised by the vote. Washington's a pretty intense place these days, which he'll tell us about. He has a bachelor's and a JD from Catholic University, graduated 85 undergraduate and 89. He grew up in Clinton, Connecticut, a small town. I looked it up on the shore. Has 3 children, is a real sort of family man. But what John doesn't know, and we didn't talk about, that we have a lot in common. John was a partner, I guess, at Morgan, Lewis & Bockius until recently in its Washington, D.C. office. I started my career at Morgan, Lewis & Bockius in the New York office. I was the second, I think, a labor associate in the office and the first hired directly from law school. Now that office is gigantic. Back then we were like 11 of us total. John spent his entire career at Morgan in the Washington office. I unfortunately left, but I have very fond memories of Morgan, Lewis & Bockius. At Morgan Lewis, John represented the trucking company in the National Master Freight Agreement negotiations. When I was a young associate, I was involved in those negotiations, spent a lot of time on trucking work as a young lawyer. I worked a lot with the Washington office of Morgan Lewis, which was one of the great experiences of my life. They had some of the great labor lawyers of all time. Bill Curtin, who was sort of the leader back then, was one of the most distinguished labor lawyers I've ever come across. But the greatest thing about the Washington office, in my experience as a young man, was they represented Anheuser-Busch, and the refrigerator was full of beer. And you could just go drink beer whenever you wanted to, which was sort of an amazing experience as a young lawyer. While in college, John worked for the Teamsters from 81 to 88 as a staff assistant. I didn't work for the Teamsters, but I worked at a union law firm in the city when I was at law school. And I think actually it's important because you get a feeling of both sides, which Morgan Lewis is sort of famous for. It's not an anti-union firm. It's a firm that really practices labor law at the highest level and believes in ethics and fairness, which I learned a lot at Morgan Lewis. John replaced Phil Massamara, another former MLA Morgan Lewis partner. So I consider this seat at the NLRB the Morgan Lewis seat, and I think it's pretty great that John is now has taken that seat. He has an incredible amount of experience as a Morgan Lewis partner, as a labor law practitioner, both with labor negotiations, multi-employer benefit funds, litigation, counseling. And in all seriousness, I think we're all very lucky that somebody as distinguished, experienced, and honorable as John is now the head of the NLRB, and I look forward to great things. John?
Thanks.
just said, being in Washington, you don't normally get nice things said about you, so that was very, very nice. I appreciate that very much. It's nice to be here with you. I was here last year, and I had just really started at the board, so I thought this time around I would give a little bit of an update on things that we've been working on at the board. I do want to mention one thing. I was just speaking yesterday with the former Morgan Lewis people there, and somebody reminded me of the beer in our refrigerators, which are now gone. We no longer have beer for lots of reasons. But as a young associate, I do remember late at night walking down the hall, and partners would be at their desks with their dictaphones, because that's how you did things back in the day. I mean, with like 3 bottles of beer on their desk, literally singing a brief. I mean, just they were. So it was, I guess that was efficient work back in the day. Before I start, I just want to say a special hello to our regional folks from our regional offices. I know a lot of our folks from Region 2, 29, 22 generally attend this meeting, and it's good to see you and be here with you. I'd also like to introduce someone who everyone may not know is our new solicitor at the board, Fred Jacob. Fred is right there. A bit of a common theme here. Fred started at Morgan Lewis and worked with us for a while. Left early and went to the board for 17 years. Was in appellate courts at the NLRB for 17 years. Went to the FLRA as the solicitor and was there for 4.5 years. And then just came back and is our solicitor at the board. We're very, very lucky to have him. Not only does he know the board very well, but he also knows what a solicitor does, which is really important. And for those of you who don't know what a solicitor does, I didn't. A solicitor is really the board's lawyer. With the Taft-Hartley distinction is our kind of communication liaison with the general counsel. Fred keeps us out of trouble. That's what Fred's supposed to do. So if I'm in trouble, it's Fred's fault. Let me give you a little bit of an update on some of the things that we've been working on at the board. One major initiative that the board has been focused on, I've talked about this before, is our case expediting process. I've been pretty vocal about the need to resolve cases more quickly, and I'm not alone. Many before me have talked about this and have urged the board to move more quickly. There have been many studies, many law review articles, many GAO critiques, congressional inquiries about the board's backlog and speed at which we decide cases. With this in mind, and after doing a fair amount of thinking about this, the board last October launched an internal pilot program. And I always say a pilot program is what you do to start something where you don't get people too nervous about it. So it's a pilot to see if we could speed up our case processing. Many of the things that we put in place have been done or thought about or written about and tried before, but we kind of really gave it a rigorous focus and follow through. And as a board, we committed ourselves to really focusing on the processing of cases and trying to do it in an expedited way. We've instituted more definitive deadlines. The board always had kind of targets, loose targets, and we've tried to hold ourselves to deadlines. I always talk to the board attorneys and say, as attorneys, I don't know how you work without a deadline. I know if I don't have a deadline, nothing gets done, and I think some of them are coming around to that a little bit. We've tried to introduce a little bit of predictability in our scheduling on the cases so that when we write a draft, the way that things used to work at the board is, for those of you who've ever seen our process, such as it is, a draft is kind of prepared and then it's then given to the other members when it's done. And there's no way to kind of schedule or predict when you're going to get something. And as a private practice lawyer, that seems kind of odd to me that you couldn't kind of predict and schedule your workflow. So we put some more predictability in that. And then we've imposed something that has been talked about forever at the board, but not ever implemented, and that is a limitation on the back and forths between dissents and the majority and dissent decisions. You'll read our decisions and you know that the dissent takes a swipe at the majority and the majority takes a dissent. That's been the kind of the history of the board's decisions. But the way if there is a dissent, the way the process works is the majority draft is prepared, completed, then it's given to the dissent. The dissent then writes their dissent, and that dissent is then sent back to the majority. The majority then responds to that dissent. Our dissenting colleague is foolish and blah, blah, blah. And then it goes back to the dissent who writes, their response. And that literally would go on for years, and back and forth. And so what we've kind of instituted with only minor exceptions when there's a need to really address a specific issue, and we've made exceptions, but we now limit this to a majority, dissent, majority, dissent, majority, and sign off by the dissent and done. I figure if you can't get something drafted in that amount of time, it's not worth saying, and we need to get the cases out. So we have been working pretty rigorously on that. I have to say we've made this, and I have directed at all times that we are to be collegial in this process. There are, of course, reasons for extensions. We have staff attorneys that are out or on maternity leave or whatever, and so there are reasons why we need extensions. But our default is our deadlines, and I have to say the board members themselves really have been holding to that. And I should say this really is about board member commitment. It's not about the staff being slow or not committed. Everything I've read really talks about the fact that it has to be a commitment by the board members to decide cases as a priority, and that's really what we've done. Now, I will admit, kind of coming from a big law firm environment where everything is forced to be super efficient, largely by client demands and billing pressures, and everything is measured, and there's statistics and metrics. I have come to realize that that is not easily superimposed on deciding board cases. Board cases come in all shapes and sizes, and the issues can be very, very difficult, and records can be very, very long. So when necessary, we have given ourselves extra time. Again, the default, though, being our deadlines. And I have to say, it generally tends to be working. I still do get questions from folks about where are the cases, and why aren't things moving along? Why aren't you putting out more cases? But it does take some time. Now, talking about these case expediting, I will say don't get too excited. We are not talking about breaking any speed or sound records, but at least there are some limits. And I should say we are really focusing on, and I think you have probably seen if you're watching our cases, we're really focusing on some of our oldest cases. Some of them, languishing at the board for upwards of 10 years, which is really unacceptable. The second thing I'd mention is that for the most part, the cases that we're talking about that the board is actually deciding and that are subject to our pilot are ones where the board is not in agreement, where there is a dissent. It's important to remember that that's a very small number of cases that the agency actually handles. In many cases, the agency resolves a vast majority of the matters before us, before it even gets to the board. And even at the board, a number of our decisions are unanimous. So let me give you some statistics just so you have a sense of what we're talking about. These are fiscal year 2018 statistics. And in fiscal 2018, the board had just under 19,000 unfair labor practice charges. I hope that's relatively consistent with what the general counsel said yesterday. He's encyclopedic on numbers of charges, but I think that's right. they all came out of the same system, so hopefully that's the same number. Based on immediate investigation, which typically lasts about 2 months, roughly 60% of the charges are dismissed or withdrawn. So that means that's the end of the case, forever, no appeal to the board. I should note that about 70% of unfair labor practice charges are resolved or dismissed, withdrawn settlement within 120 days. So that means that in the first 4 months after a charge is filed, the NLRB accomplishes final resolution, meaning the end of the case, no appeal, roughly 70% of our cases. Of the remaining cases not dismissed or withdrawn, the General Counsel or the Board's regional offices worked out settlements in 97.5% of those cases in fiscal year 2018. So kudos to the great work of our regional attorneys and resolving those cases like they do. Really, that's where the heavy lifting of the board is done on a day-to-day basis. In continuing with my statistics here, in fiscal 2018, our Division of Judges issued 150 decisions and achieved 449 settlements. The rest, roughly 5% of the cases that get litigated to the board, a substantial majority of those are decided by a unanimous board. 85% in fiscal 2018 were decided by a unanimous board. So we really are talking about a very small number of our overall agency caseload. But those cases that do come to the board, as you all know, are important ones, and they often involve important legal matters, and it's important that we get them decided quickly. And I should also mention that our case processing pilot is part of our agency's larger published strategic plan and goal to speed up our case processing under General Counsel Rob's leadership, and he probably spoke about this yesterday. The regions are working on expediting the case processing at their level, I should say, and I hear it when I speak to the regions all the time. The regions have always had firm deadlines and are held to strict metrics, and I think it's frustrating sometimes for the regions when they process a case that it gets to the board and sits for 4, 5, 6 years. I've heard that firsthand from a number of attorneys, both when I was in private practice and now at the board. So we owe it to the regional offices to move cases along at the board as well. And that's one of the reasons that General Counsel Rob and I kind of just talked about having our strategic plan be aligned so that both boards is processing cases more efficiently and quickly in conjunction with what is already very, very quick processing at the regional level. On the board side, in addition to the case processing pilot that I talked about, we've beefed up our ADR program at the board level. This is post-ALJ exceptions and prior to board decisions or board consideration in an effort to try to resolve cases there as well. And then finally, I will note that the board, because this is a pilot, is committed to looking at the results of what we've accomplished in the pilot, how quickly things are moving, or has it actually slowed the process down. We're looking at how we might improve what we've done, and also look at how we might improve the overall streamlining of the case processing. Now, I'm not naive about this. Many prior chairmen and prior board members have attempted to expedite case processing. There are lots of reasons why there are delays. Often it deals with board member turnover when a new board member joins or rotates off the board. There's a reassignment process. The board member and their new staff have to get up to speed on the cases, so that takes time and slows things down. Also, when the board gets down to 2 or 3 members, the caseload per member becomes higher, and sometimes when you get down to 2, the Supreme Court has said that we're not supposed to be deciding cases, so it comes to a halt. So, but like I said, everything I've read And I think the board feels it really comes down to a commitment by the board members. Now, I will say, I think there's probably not one of us board members now who don't wake up some days and say, why the heck did we do this? It'd be a lot easier if we just did it the old-fashioned way and not push ourselves. It's because it is a lot when these deadlines come up and we're all holding ourselves to deadlines. And we keep track of which office is meeting deadlines, kind of a big firm, law firm way of doing things. So there's a little bit of competition between board members on making sure we're meeting deadlines. But it's worth it, and I think it's something that we really have to do. And in my humble opinion, I will say it should be our focus and a priority. That's why we were appointed to the board, is to decide cases, and we should be trying to create a culture of deciding cases more quickly. You know, many people talk about the purposes of the Act and about how best to advance the purposes and goals of the Act. Making someone wait 5 or 6 years to get reinstated because they were brave enough to stand up to their employer on behalf of their fellow employees is not advancing the purposes of the Act. Or waiting that number of years while a workplace sits in limbo, waiting for us to resolve a labor dispute, whether that be an election or unfair labor practice, does not advance the purposes of the Act. So, in my view, one of the primary functions and the focus of the board, given our current statutory scheme, to advance the purposes is to get cases out more quickly. So more to come on that. I'm hopeful that we can continue to build on our successes and that you all will start seeing some of our decisions coming out a little bit more rapidly. Some of the other things that we've been focusing on, I'd like to mention, is our rulemaking. I have been talking a lot about rulemaking since I took over the job. It's been widely reported. The board majority is very interested in doing more notice and comment rulemaking. As you know, we historically have addressed most of our issues at the board through case adjudication. It's not that the board doesn't have authority to do rulemaking. We do. It's in our statute, and the Supreme Court has said we do. And the board has, at times throughout our history, done rulemaking on certain topics with varying degrees of success. Most recently with the union election procedures, but we just haven't done it all that often. I should say, despite not having done a lot of rulemaking in the past, the board has a very good technical capability and expertise in the Administrative Procedures Act. We have folks that were involved in the election rules and in litigation that followed. So we have some really strong expertise in that area. So I've been a big proponent of rulemaking for many years, largely because I really think it provides the board a way to provide better clarity and predictability in our precedent. There's reasons why most other federal agencies engage in notice and comment rulemaking. It's fairer. It provides an opportunity for everyone to participate in the process and provide their comments. Unlike as we adjudicate cases now, it's simply the parties that tell us what we should do on a case. Sometimes we ask for the parties for amicus briefs, but then that's really just folks that can afford a lawyer to weigh in. In the public, the notice and comment rulemaking, the public in general, anybody can write in, and I will, as I talk about later, everyone does. I think it also is more comprehensive and coherent way to address matters. Again, when you're looking at a case, you're looking at the specific facts of that case, as opposed to being able in rulemaking to look at a whole broad area of a particular topic and be able to address all the nuances and specific factual issues that may be out there. When you change a rule, which the board has been known to do once in a while, when the political winds change, there's a rational way to change the law As you know, our practice has been to apply our new rules when we change the law retroactively, which is often not all that fair. In notice and comment rulemaking, if we're going to change our precedent, it provides a rational way to do that. You propose the new precedent, what we're going to do. You ask for comments on that. You issue what you're going to do. Everyone knows what the rule will be. There's a period of time where there will be an effective date, so everyone can plan for when that's going to happen, and then it is prospective. And so to me, that it makes any kind of changes a much more rational way to do things. When I speak about rulemaking to our regional attorneys or any group of labor lawyers, they look at me like, all right, so this rulemaking is going to put me out of a job. And I will say that is not at all what is happening. I'm a labor lawyer. I need a job, so that's not at all what we're talking about. I don't think we will ever get out of case adjudication. Our cases and the issues that come before us are just too fact specific. But I think through rulemaking, we can provide better clarity and predictability in our precedent, and that will make our case adjudication processing much more easy, and efficient. So let me talk a little bit about some of the specific rulemaking we're focused on, and this has all been disclosed publicly. First, our rulemaking on the joint employer standard. The joint employer issue has been, as everyone knows, probably a very hotly debated topic under the National Labor Relations Act. For many years, we issued our NPRM in September of last year. The comment period ended in February of this year after we granted 3 extensions, including a further extension following the D.C. Circuit's Browning-Ferris decision, a little end-of-the-year surprise present that we received in December, and we extended the comment period to allow the public to address the issues raised in that decision. We received close to 29,000 comments. They are all posted publicly if you'd like to look at them. There's just a copy of a middle finger, which Member McFerrin said that was her, and I said no. They are all there. Friends at other federal agencies say that 29,000 comments are not that much. I will say for our little agency, it's a lot, and we are working diligently to process those. I think the number of comments, though, and the level of sophistication in most of the comments really shows the interest there is out there in clarifying this area of the law. So like I said, we're working on reviewing those comments, very interested in hearing about them and considering what each of the commenters had to say. I can't give you a timetable on when that's going to be done or when we expect to issue our final rule, because we're going to take whatever time is necessary to review all the comments and to make sure we get the rule right. We are also considering rulemaking regarding changes in the 2014 election rules. As most of you know, there was a request for information in December of 2017 before I got on the board. The board asked whether there should be changes in the 2014 election rules. We received over 7,000 comments. We have been through all those comments, and they were very thorough, well done, helpful, and they contained a lot of good information. And after a comprehensive review, the board has decided, we announced this publicly before, that we are going to do rulemaking on the election rules in a series of smaller rulemakings. The first that we're going to handle is the board's going to issue an NPRM that will focus on really two and a half important issues. One is the board's current blocking charge policy. The second is the board's The second is the voluntary recognition bar, and Related to that is we're going to deal with an issue in the construction industry of the 8F conversion to 9A contracts, where we've had several cases and a few cases that have actually been kicked back to us by the DC Circuit. So we hope to have that NPRM out. I had hoped to have that NPRM out by now. We are still working on it, and I'm reluctant to give predictions, but I'm still hopeful we can get something out early to midsummer. We are looking at other aspects of the election rules that may require some changes, and we are hoping to do some rulemaking and potential revisions on those as well, just behind the first set. We've also announced plans to pursue, and hopefully the building will not start rocking when I say this, pursue rulemaking on the issue of whether students who perform services at universities should be considered employees under the Act. This is an issue that has been hotly debated, and the board law has flip-flopped several times over the years. I know there's strongly held views, although I candidly have to say my practice has never been, or was never in colleges or universities, so I'm not as familiar with this issue as others are, but I am looking forward to learning about it and hearing about it. I have to say, I think notice and comment rulemaking on this issue is a good way to deal with it. The cases that are out there right now deal with very specific issues, and I think rulemaking will allow us to have do a comprehensive look at how we can potentially deal with the myriad of issues and factual differences along various campus jobs. So we're excited to be working on that. We are considering other areas of rulemaking. One we have announced before, which is trying to rationalize our precedent as it relates to access to property, dealing with non-employees, off-duty employees, contractors. Our law, if any of you have dealt with it, is not only not particularly clear, but it's spread out across lots of different precedents. So the idea would be to try to pull that together and have some way that where if somebody has a question about access, they can go to one place and deal with it and know what the answer is. So that is where we are on our rulemaking. How am I doing for time? Okay?
Sam, should we give John more time? You started him late.
Yeah, that is true.
Go ahead.
That is true.
Right.
You are the boss,
I'm advocating for you, John.
I'll talk real fast. Let me just talk about three other things. One, handbooks, employer policies, and rules. A lot of discussion about post-Boeing guidance. The General Counsel has put out a memo providing some guidance on that. I can't tell you, we are working on post-Boeing decisions. I know Boeing is super clear and super understandable. We're trying to figure it out ourselves. I love my former colleague Phil Miscamara, but Boeing is a schlag, and we're trying to provide as much guidance to everyone on that as we can. I can't tell you exactly what we're doing, obviously, because the cases are still in process, but I can tell you we are working on those cases, and I hope to have them out soon. We are dealing with cases we call the U-Haul cases about access to the board and restrictions on access to the board processes that might be in rules or mandatory arbitration agreements. We did request briefing regarding the board's jurisdiction over charter schools. We have the briefings on that, and we are working to deal with that issue. Interestingly, in that case, the case before us, it was KIPP Academy. The union was the one there asking for the board to not assert jurisdiction over the charter school, and so this is an area that needs, I think, some clarity, and so we hope to do that. Rather do it under rulemaking, but we've got our limits. And then the final thing I would mention is the EEOC confidentiality, internal investigations, every time I speak to any group, particularly HR executives, there's a lot of concern about our board precedent under Banner Estrella and the board's position that an employer cannot ensure confidentiality in any kind of internal investigation. We do have a case before us now. The General Counsel has made that public, that he has sent us a case, and we are in the process of reviewing and hope to have a decision on that. I say shortly, but nothing is shortly at the board. We'll have something soon. Okay, so I've gone on long enough.
Chairman, you ready for
Thank you
some
very much,
questions?
and I'm happy to have questions, yes.
Okay, there are microphones on either side of the room. If you have a question for Chairman Ring, please come up to the microphone, identify yourself, and then ask your question.
Just remember, when you ask me a question, I actually can't answer any kind of forward-looking questions. I tell this story for my Senate confirmation. I was not able to actually answer any questions. But every senator comes in and asks this question anyway, so you have to go through this whole, I'll have an open mind, I'll look at the issue, and at the end of my Senate confirmation, my daughter said, "You sound like one of those shifty politicians who never answers any questions." I was like, "Ugh." And then we went to dinner that night, and my son was sitting. He's a smart aleck. Labor lawyers' sons tend to be there. Daughters tend to be there. He said he's sitting there looking at the menu, and I said, "What are you going to have?" He goes, "Well, Dad, I have an open mind. I'm going to look at all my options." So oh, here we are. I've got an open mind.
Hey, Chris Ott for Bloomberg Law. Just a question on joint employer. We, and I think some other people, noticed that you all had it on the long-term list on the regulatory agenda, normally saved for stuff you don't expect to get to in an entire year. So is that accurate? And if so, I guess the question is, why take on these other rulemakings when joint employer is still hanging out there and you have limited resources?
Yep. I will try to explain this. This is a technical question that there's technical people at the board who have answered this. Fred could probably answer this better than I. But when you have to file on the unified agenda, which all agencies have to file on, you have to give a date. Because we cannot predict a date specific, we put it on the long-term agenda, which means it's after the next filing, which is September. We are going to take the time we need. Our ethics people tell us, and our lawyers tell us, that we can't say we're going to have it done in August, because it may not be done in August. So we may have it done in August. I mean, depending on how quickly and how quickly we can come to a consensus on a rule. But the real reason is because we couldn't predict or stay definitively that we would have it done before October, I think was the date. So it's not really a matter that we won't have it done or that we are pushing all those things off. Unless you can definitively say you're going to have it done by a certain date, I'm told you have to put it on the long-term agenda.
And why take on other rulemaking given how small the agency is, how limited the resources are when joint employer still needs to get finished?
Oh, we think we can do. We can do both.
Okay,
Yep.
thanks.
Or we can do all of it. I mean, but I will say, I mean, we are being smart about this. I mean, we're not just doing all of them at once. We have them kind of spread out, and there are lots of I'll just say board members have lots of ideas about what we could do in rulemaking, and we're not doing all of them at once. We're going to be smart about it and take our time and make sure we have the resources. I will say, as I said before, in rulemaking, we have a really good core of people that know the Administrative Procedures Act. We have to build on that. That's one of the reasons we're not going to do other rulemaking, like on charter schools. But I really want to build that core internally, organically. We've got a bunch of really, really qualified staff attorneys who are interested in rulemaking and interested in the APA, and so they've expressed interest in doing it. So we're looking at trying to build from internally, and if we have to bring in external expertise, we can do that as well. No questions?
My name's Aaron Samsel. I'm an attorney in the National Labor Relations Board Contempt Branch. I was curious if you have a position on whether Section 7 protects employees from discrimination for engaging in collective or class actions in litigation.
I do. I have an open mind on that. That's one of those things, we've got some cases before us right now, so I think it's probably better I don't state what we're doing in that area. But it's that post epic is an area that we've got a lot of cases that we're dealing with. So, all right. No
All
other
right,
questions?
let's give Chairman Ring a hearty
Thank you very much.